Mr. Owens' expertise is in zoning, subdivision regulation, and other land use control, city and county planning, and environmental protection. Without further ado, I will hand it over.
Great, thanks very much. Delighted to be anybody who's doing zoning stuff at 9 o'clock in the morning. You have my admiration. Die-hard crowd here. What I'd like to do is do this relatively informally. We're a small enough group. Feel free to jump in at any point, ask questions, make a comment. Generally, what I'm going to tell you is what the state law requires in the normal practices. If you are doing something different, a different process than I described, it'd be a good time here amongst friends to say, oh, we're doing X, Y, or Z, and it may be that you've got an interesting, completely legal and acceptable variation on the state theme. It may be that you're acting blatantly illegally and improperly, in which case it's better to find out here amongst friends than when a reporter calls you the morning after the meeting to inquire as to why you did it the way you did it. Don't be shy about jumping in and raising questions, comments, observations as we go. Schedule-wise, what I thought we'd do is go 50, 60 minutes, something like that, take a short break, 5 or 10 minutes, do refreshments and the like, and then go for another segment and wrap up somewhere in the 11 to 11:30 range. The latest will be done by 11:30, so you can get out and go do other things. Anybody wants to stay on afterwards and chat zoning, we can do that as well. But we'll certainly wrap up by 11:30 at the very latest. And if we finish at 11, we're done. We don't have to sit and wait till the clock chimes for us to leave. Fair enough? Cool. All right. So let's talk about the Board of Adjustment and what it does and why it does what it does. And this first point is absolutely critical. What the Board of Adjustment does in most of its work is make decisions of a quasi-judicial nature, in the nature of a judicial proceeding, similar to, not exactly the same as, but very close to, a judicial type proceeding. You are, when you decide things like special and conditional use permits, variances, and appeals, you are affecting folks' property rights. The applicant, for example, with a special use permit application, whether it's done by the Board of Adjustment, City Council, County Commissioners, Planning Board, and under North Carolina law, you can assign final decision-making on special and conditional use permits to any of those boards. But when you make that decision, when somebody makes an application for a special conditional use permit, they are legally entitled to that permit. They have a property right to the permit, provided they meet the standards in the ordinance. And the role of the board making that decision is to gather evidence and make a decision as to whether or not the standards are met. And the same is true for a variance. If somebody applies for a variance, if they meet the standards, they are entitled to that approval. If they don't meet the standards, they are not. They have a property right to that approval if they meet the standards. So the Board of Adjustment's role, and it's true of any board making these decisions, is that you are not adopting policy. You're not deciding what the right policy ought to be, what the standard ought to be. What is good, true, and just for your community is not your job. If you don't like the standards, you think the standards are too strict or not strict enough, the answer is run for city council and amend the ordinance and change the standards. A Board of Adjustment's job in any board making a quasi-judicial decision is to take the standards in front of you and apply those to the facts of each individual case as you get them. And as part of that, you have two jobs. One, to figure out what the facts are, and secondly, then to apply those facts to the standards in the ordinance that involve some judgment and discretion. If the standards are entirely objective, 20-foot setback, 60-foot height limit, things you can pull a tape measure and do, then that becomes a ministerial decision that's assigned to staff. They pull the tape measure, they apply the ordinance. A quasi-judicial decision has a standard that involves some judgment. How much hardship do you have to have for it to be unnecessary hardship? What is, if it's a special conditional use permit, what's harmonious with the surrounding neighborhood? What would be a significant adverse impact on neighboring property values? Those kinds of things that involve judgment, discretion. But very importantly, it's applying the standard that's in the ordinance. So if you look at it and say, well, gee, I think this person we ought to approve this sort of thing, but it just doesn't meet the standards, you don't have any option other than to not approve it and maybe suggest that the standards get changed in the future. That's one of the things when I talk to boards of adjustment that's very important, is emphasizing that your job is not to dispense seat of the pants justice as you see it. Your job is to apply the ordinance in front of you in a fair, efficient, and effective fashion. Everybody, sort of sermonette for the morning, get that out of the way first thing. Everybody cool with that? All right. So let's talk about how you go about doing this sort of thing. I'm going to skip that. This sort of emphasizes that point. I think this is the way, folks old enough to remember dear old Andy. I think a lot of boards of adjustment see themselves as this role, particularly in smaller towns and rural counties, that we are sort of here to be fair, to be reasonable, to get the right result. And if we sort of work around the law, so be it. The alternative is this is how the courts see you, and this is increasingly the case. Our courts of appeal, when your decisions get challenged, goes to Superior Court, onto the Court of Appeal, see a Board of Adjustment as a fairly formal, nearly courtroom type procedure. And every year that goes by, our courts are getting stricter and stricter about these requirements, about the kind of evidence you have, the kind of process you run, and making sure it is done right. And they do not cut you a whole lot of slack. They are not seeing you as Andy Taylor. They're seeing you in the role of Hamilton Berger and Perry Mason. So, one other sort of introductory thing, interspersed within what I'm going to talk about this morning is a new law that took effect October 1st that rewrote the Board of Adjustment statute and the statutes that apply to all quasi-judicial decisions. Several of you have already amended your ordinances to incorporate the changes that are put into this, that this law put into place. Even if you haven't, this law applies. This law applies to any decision made on or after October 1st, 2013. So it is in effect today. It applies to anything you do, anything you did last month, anything you do this month, and going forward. And so I'll raise a couple of those points as we go. But for the most part, this law didn't make major substantive changes. It clarified things a little bit, cleaned up the statute, reorganized it a little bit, so it's a little easier to follow, modernized the language. The Board of Adjustment statute's been on the books since 1923, and some of the language was a little archaic. It's been amended something like 40 or 50 times over the years with sentences added. Some of the sentences ran on for nearly half a page. Shortened that up, made it a little simpler, straightforward, and for the most part did not make major changes. But it did add some uniformity requirements so that everybody will do the same thing around the state. So as you move from one town to another, you have consistent procedures relative to notice, where you file things, and how you do decisions. Plus, it took a lot of the case law that's developed over the last 40 or 50 years and put it into the statute so that it's now clearly laid out in the statutes instead of just being in the case law. One of the first things it did is a fairly minor piece, is there's now a uniform notice requirement for all hearings on quasi-judicial matters. So for any Board of Adjustment decision on variances, appeals of staff decisions, special and conditional use permits, whether it's done by the city council or the Board of Adjustment. There's a uniform notice of the hearing. So whenever you do a hearing, you have to do a mailed notice of the hearing to the property owner and each adjacent property owner. You have to post the notice of the hearing on the site 10 to 25 days prior to the hearing. But you don't have to publish an ad in the newspaper. So that anybody who wants to know about the hearing, the Board of Adjustment is doing a hearing, that has to be done. If you want to add a newspaper ad, that's fine. If your ordinance requires more than that, if your ordinance says mail the notice to everybody within 200 feet or 500 feet of the property, then you have to do what your ordinance says. In addition, you can't do less than this. You can do more, but not less. But that's one of the new notice requirements that's now uniform across the state. The statute used just to say, provide reasonable notice to the parties. Now it says, this is what you have to do. Just an example of the uniformity requirement. A lot of what I want to talk about in the first segment of this, what I split this up as we go, the first part, the next part of what we're going to talk about is the process you have to follow. Then we'll end up with talking about specific types of decisions, appeals, variances, special and conditional use permits to the extent you do any of those. But the first part of this, and what we'll talk about before our break, is the process you have to follow. And the process is there because one of your two jobs is figuring out what the facts of a case are. So when you hold a hearing, you're doing an evidentiary hearing, not a legislative hearing. The difference is the only purpose you hold a hearing, the only reason you do a hearing is to gather evidence. To gather evidence to determine what the facts are for your case. Very much unlike a legislative hearing. If you're doing a rezoning, the local is changing the zoning on a piece of property, that's a policy question to amend the ordinance. And the reason you hold a hearing for that is to gather citizen opinions as to whether it's a good idea or not. And you'll have citizens show up and say, yes, this is absolutely wonderful. I'm bringing a needed and vital service to our community. It's going to provide jobs and taxes, and it'll be just wonderful. And you'll have somebody else who stand up and say, this is the worst thing that could ever happen to our community. It'll be the ruination of civilization as we knew it. I moved to this town to get away from this sort of mess, and this will just be absolutely awful if you approve that. And those are both perfectly legitimate things to say at a rezoning here, because you're making, ultimately the city council, county commissioners are making a policy choice of what would be right for the community. 99 times out of 100, if a citizen shows up at a Board of Adjustment hearing, an evidentiary hearing, and says, this is a great thing or this is a terrible thing, that's almost always totally irrelevant. A group of citizens offering you their opinions as to whether it's good, bad, or indifferent doesn't really matter. I mean, it matters in a political science sense, but it doesn't matter in terms of your decision making. Because the purpose of your hearing is not to gather citizen opinions as to whether this is a popular or unpopular project, whether people like it or don't like it. You're not holding a hearing to gather opinions. The only purpose of an evidentiary hearing is to gather evidence. What are the facts to help you then apply those facts to the standards in the ordinance? And when boards of adjustment lose in court, by far the most frequent reason you lose when somebody appeals a decision is the court looks at it and says, okay, you concluded X, Y, and Z. Where in the record are the facts to support that conclusion? Mr. Attorney, point me in the record. Is it page 27 that there's evidence about property value impacts? I want to see it. And if the evidence is not there in the record, you lose. If there's not competent, substantial, and material evidence, that's what you've got to have in the record to support any conclusion you make. And the purpose of the hearing is to gather competent, substantial, material evidence. to support your decision, whatever it is. And a key thing to remember is that if one of these cases goes up to the U.S. Supreme Court, there is never going to be another hearing to gather the facts. You are it. What the Board of Adjustment does establishes the factual record for that case. The Superior Court doesn't take any new evidence. No appeals court takes any new evidence. The record is what you establish at your hearing. So you need to make sure that all the facts you need are there. The facts in the record, the application, the reports that are submitted, the testimony you receive at the hearing, all of that is the factual basis for this case. And that's the only reason you're holding a hearing, is to gather good quality evidence to aid in your decision making. That, anybody want to offer a dissenting point of view, a variation of that? Do you ever get citizens that just show up and say, I don't like this thing. I sure hope it's not good for our town. I sure hope you'll vote no. Thank you for your time and attention.
Would you explain the hardship part of that?
The hardship, one of the standards you have to apply for a variance is that the applicant has to show you that there would be unnecessary hardship from a strict application of the ordinance. What counts as unnecessary hardship, we're going to get to in our second segment, after the break, as they say on TV. Come back after the break. Don't get your donut hole and leave. Come back and we'll talk about what constitutes. I think that is probably the single hardest determination that most boards have to make. How much hardship is enough to be unnecessary and how much is necessary hardship. And we'll spend some time talking about exactly what that means. The statute did change some of that. Yes, sir.
David, I have a question of clarification, more or less. In gathering the evidence to make, for the board to make its decision, most frequently is testimony.
Yes.
Of the applicant, and then the town presents its case also. It's not usually an adversarial per se thing, but when you have a person requesting a variance, an applicant said, well, the building inspector told me that this was okay, or my surveyor said that we could do this, is it necessary to tell the person, well, I'm sorry, we can't use that because that's not substantial, they're not here to testify,
Right.
and we can't accept, do we just not say anything and just know that we're not supposed to accept that as substantial, or do we really hurt their feelings by telling them?
Yeah, that's an excellent point. I mean, you will sometimes, this is like a court proceeding, but it's not a court proceeding. The courts say you've got to generally follow the rules of evidence, but not as precisely and rigorously as you would in a court. And exactly what it means when you're acting sort of like a court, but not exactly like a court, is sometimes hard to draw that line. And we'll talk about different types of evidence, hearsay, opinion evidence, and all that as we go today. But when you are presented with the fact that somebody is giving you something that you really can't use, how do you handle that? Somebody brings you a petition, for example. I've got signatures here from 20 of my neighbors that say X, Y, and Z. Well, that's technically hearsay testimony. We don't know what the neighbors really said. What their opinion is probably doesn't matter. And it's not evidence you can rely on to make your decision. But it's kind of awkward to say, you can take your petition and stuff it. We're not going to receive this. We're not going to let it. I mean, somebody's taking the time to do it. Somebody's there to offer you their opinion. You've got to be polite. You've got to be cordial. And I think what the courts would say is it's perfectly fine to accept that evidence, but you've got to be careful not to rely on it to make a critical factual determination. If somebody's offering you evidence that's basically technically inadmissible, you've got to be very careful not to rely on that. And some boards, you certainly have the discretion to say, well, we appreciate that, but unless the surveyor is here to corroborate, confirm, to answer questions about that, we really can't take that testimony. We can't use that. And it's sometimes helpful to explain to people that why you can't rely on it. Which, as an aside, if you don't have, I think it's very useful to have is a little pamphlet, a one-page front and back, sort of the basic rules on quasi-judicial proceedings to hand out to folks. But practically, when people appear before the Board of Adjustment, they don't, for the most part, know the difference between legislative and quasi-judicial. You're lucky if they know which unit of government they're appearing before. And it's a foreign environment for most folks, whether they're the applicant or the neighbor who's concerned about it. They just know they need to get your approval or your denial, and they're either for it or against it, and somebody told them to come down at 7 o'clock on Tuesday night because this was coming up. So some explanation to folks as to what this is, how it works, I think is extremely helpful. There's some of those around. Do any of you have those already? Manio's nodding your head yes. Manio says yes. The state bar has a couple of handouts that you could adapt. But I think it's very helpful to give that out to folks and also to explain at the beginning of the meeting. The purpose of this hearing is to gather evidence. It's a fairly formal proceeding. Rah, rah, rah. So explain that. 30-second, 1-minute explanation up front to help orient the people who are appearing before you. You know, there's a reason we're doing what we're doing and why we're doing it. It's not just because we're being overly officious or we're full of ourselves. This is what the law requires and why we're doing what we're doing. Does that answer the?
It's a good start.
Good start. All right.
Thank you.
If you did accept that petition, does it become part of the record?
Yes. Anything you accept. Now, where I would draw the line and where I think you really do need to draw the line, there's some things that are fairly harmless to take, accept the testimony, accept the document, put it in the record, but make it clear that you're not relying on that for any factual determination. If somebody starts offering you testimony or documents that are irrelevant, immaterial, then I think you need to say we cannot accept that. We cannot hear this sort of test. Somebody starts testimony, look, Joe Blow has applied for this permit, but let me tell you, this guy's a jerk. I've known him since high school. He was a no-good cheating scum back then. He ran off with my sister to Las Vegas. He has been no good. I mean, that you need to cut off fairly quickly as irrelevant testimony, and because that can really taint the record. You don't want bad stuff in the record. Somebody starts, with ethnic bias, racial discrimination, religious bias, anything of that nature starts coming up at your hearing, you need to stop that fairly quickly. Or if they're offering you evidence that letters about stuff that's totally unrelated to the project, that you don't take. So irrelevant, immaterial sorts of testimony, especially if it is the kind of thing that if the court thinks you actually relied on that, you would get zapped for, that you don't want in the record. So that you have to politely say, well, appreciate your opinions, but we need to stick to the facts here. If you've got evidence that are relevant to determining whether this application meets the standards or not, we'll be glad to listen to that, to take your testimony, but you're getting too far afield here. We need to stop that and focus on the standards. That, I think, is important to do. Because you see folks say, well, yeah, they ran on for 15 minutes. We had 8 people stand up and say this would be terrible because it's going to be occupied by a bunch of Hispanic farm workers. And we had a case like that not so long ago. But we really denied it because of the adverse impact of traffic. But there's virtually no evidence on traffic and a whole lot of evidence on ethnic animus towards the applicant. That is simply, A, it's wrong, and B, it's asking for trouble. So that you need to cut off fairly quickly.
So, if staff receives an applicant, or an application from an applicant for a Board of Adjustment hearing.
Right.
And say all their evidence that they submit is not evidentiary, it's just because I wanna do it,
Right.
and, that kind of stuff. Are we still required to send it on to our Board of Adjustment and let them do the finding of fact, saying that it's irrelevant?
Yes, the staff cannot, one of the roles of the staff in your application form should be designed to solicit the kind of information you need to make this decision. And I skipped over a slide early on. But the burden on producing evidence to allow you to make your decision is on the applicant. It is not the staff's job to give you the evidence you need to make a decision. It's not the neighbor's job to produce evidence that they don't meet the standards. The burden, legal burden, is on whoever is asking for the approval, has to submit sufficient evidence to you to show that they meet that standard. So the burden is on the and usually the application form asks them, why is this an unnecessary hardship? Why is this consistent with the spirit, purpose, and intent of the ordinance? And so forth. Or for a special use permit, we need the following types of information and data. So a lot of the information you need is going to be in the application itself. Then the applicant will show up and offer testimony. If there is insufficient evidence to find that they meet the standards, the answer is an automatic denial. If they don't meet the burden of giving you enough evidence to determine they meet the standards, the answer is no, simply because the evidence isn't there to support it. But the staff cannot make that determination. That's a decision the board has to make. Now, one of the things that is informal in all of this is that part of the staff's job is to provide the form, provide assistance to the applicant, say you need to do this, this, and this. One of the things you need to clearly get a feel for with your staff is how much do you want the staff when somebody has an application that's clearly insufficient, or they apply for something that you can't get a variance just because you want it. It doesn't matter how badly you want it. And sometimes folks say, well, I really, really need this, and I want it. Well, the depth of your feelings doesn't really matter in a legal sense. So how much do you want the staff to say, well, you've applied for this, but I can tell you this is a non-starter. Just because you really want a variance doesn't mean you can get it, and there's no hardship here. One of my favorite cases back when I worked with the state is we had somebody ask for a CAMA setback, an oceanfront setback. And one of my jobs at the time was doing the legal work with the Coastal Resources Commission long, long ago in near ancient history. And the reason these people wanted a variance and to build their house out closer to the ocean inside the 60-foot setback was that if we built the house as designed, when I'm standing at my kitchen sink and looking out to the north, I'll be looking at my neighbor's house. And I want to get out on the beach so that my view standing at the sink is to have a better view of the beachfront. Ma'am, that's not a hardship. I appreciate your desire to see the beach and people sitting out on it, but you can't get a variance for that reason. But as a staff person, I couldn't say, you're wasting your time and money to make that application because it's going to be people will snicker and vote no, and they have to vote no. You haven't presented any hardship here. But as a staff member, I could advise them, say, okay, that's probably not a good idea. You're going to need a little bit more. But some boards say, we don't want the staff to tell people you're wasting your time and money. If people want to fill out the form and pay the money, take it on to the board and let the board, but the board's ultimately got to make your decision.
If you get an application and the application is filled out complete and they paid their money, but they've not attached any of their evidence, they're gonna do that later. Is that okay?
Yes.
Okay.
Anything, if you want more of the evidence up front, then you can require that as part of the application. They have to have a complete application. If you say you have to fill out the application and you have to attach whatever, a survey, a site plan, this, that, and they don't have the attachments that are required, then it's an incomplete application and you don't go to the board until you get a complete application. But if they're gonna submit information, a report from an appraiser, an engineer's report, whatever, and they want to just present that at the hearing and not in advance, that's acceptable.
So you're saying that staff would not be obliged to say, well, just move the sink?
The staff can advise the person to move the sink, and I did in that case. But they wanted their whole house well out in front of the neighbor's house. They said, well, everybody else is in line, but I want to be closer. Well, too bad, but I could tell her that.
Yeah.
But she didn't have to listen to my advice.
I
And she didn't.
understand that, but I mean, would you be obliged to, I guess is my point.
Am I obliged to? No, the staff is not obliged to tell them anything. And that gets to the sort of, what kind of informal policy, how active do you want your staff to be in assisting an applicant, in advising an applicant? I mean, everybody wants their staff to be customer friendly. But your customer is the applicant, it's the neighbor who's affected by that project, it's the general public, it's the elected officials who adopted these policies that they want fairly and effectively implemented. You got a lot of customers when you're the staff, and it's not just the applicant. So that's one of the things I think, managers, staff, boards all need to be on the same wavelength of how much assistance do we want our staff to provide applicants and help people through the process, because it is complicated and difficult and you want to make it straightforward, but the staff can't do the work of the applicant. I had one board that said we don't want the staff tainting the process by offering your opinion and trying to characterize. We want the staff to be neutral on the sideline. Other boards say, look, we want you out there working with these people. If the neighbors have a question, if the applicant's got a question, help them out, show them how to do this, clean it up before it gets to us. There's no right or wrong answer to that. It's what is right for your community and how much you want your staff engaged informally in that process up front. But the legal burden, back to my lawyer's role here, is on the applicant. The applicant has to give you enough evidence to make your decision. If the neighbors are opposed, then they have to give you evidence to show the standards are not met. And you make the decision once you get all the evidence in front of you.
Oh, so what's your opinion on the staff reports for variances?
How many of you, by the way, I didn't do this at the beginning. How many of you are board members, Board of Adjustment members? Anybody on a elected board, council, commissions? Oh, good. We're all appointed board members, and everybody else is a staff person, right? That didn't raise your hand. And let's see, which jurisdictions we got? Kitty Hawk, Southern Shores, Currituck County, oh, cool. Dare County, Duck, Nags Head, Manio, Southern Shore, oh, we got the Kildow Hills, our host. Anybody I left out? Duck. Anybody from Duck? All right. Okay. Staff reports. How many of you have, when you have a quasi-judicial, the staff submits a staff report as part of your package? Most everybody? I would say almost, I don't know, I don't have a, some things we've done surveys for, and I can give you good, accurate, empirical data as to what the practice is around. Other things are just more a seat of the pants estimate. I would say probably 80 to 90% of local governments ask the staff to do a staff report. that does an analysis of every application, a variance request, a special conditional use permit application. It is pretty common for the staff to do a report that goes through and analyzes from the staff perspective whether or not the application meets the standards. And then the staff person comes to the hearing, presents a report, testifies about it, answers any questions about it. That is the most common practice. And there's nothing, that's perfectly fine, legitimate, and if that's one of the things you want your staff to do, that's perfectly fine. And typically you have to then work up an order for the presentation, and usually it's the staff will present their staff report and explain the project. The applicant will present their case and answer questions. Any opponents will offer their testimony. Folks get a chance for rebuttal, and then you go ahead and vote. One of the things that there is a lot of difference around the state is, should the staff report include a recommendation? The first part of the staff report is an analysis, factual information, how this meets the standards or doesn't. And then sometimes the staff report will say, we recommend that we think it meets the standards and we recommend that it be approved, or we think it doesn't meet the standards for the following 4 reasons. And last time we did a survey on this, it was about 50-50. About half of the jurisdictions asked the staff to include a recommendation saying, we've hired you, we want your professional opinion as to whether or not this meets the standard. About half the board said, it's our job to make that conclusion, and we don't want the staff, we want just factual, neutral information from the staff. We don't want a recommendation from you one way or the other. And you can do it either way. Legally, there's nothing, the staff's recommendation is just one more piece of information and isn't legally binding. Some boards want it, some boards don't. You can do it either way.
You kind of hit on this in so many words, but the same evidentiary standards then apply to the staff's report.
Yes, absolutely.
But just by its nature, aren't the applicants already appealing a staff decision? Doesn't the board already have the recommendation from
And
staff?
I'm going to get to that on
point?
appeals. But on variances, the staff, on a variance or a special conditional use permit, the staff may or may not have a position. On an appeal of a staff interpretation, you already know what the staff's
Right.
view is. And the staff member's going to have to be there and explain why they did what they did. So, evidentiary hearing to establish the record. Just back up. Oops, I'm backing up. Quick thing, one of the changes in the new law, it used to be, let me back up 2 steps. The first step to back up to is when people appear before you to offer testimony, they are witnesses. And one of the important things to remind folks is you are not here to comment on the wisdom of this application. When you appear before us, you are a witness offering testimony. So everybody who appears before you to offer factual information should be sworn in as a witness. The staff, the applicant, any surveyors, engineers, planners, anybody offering you factual information, testimony, needs to be sworn in. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? Without that, it's not competent testimony. So you need to be sure you get the witness sworn in. There is a possibility that if everybody waives oath, you can get by without sworn testimony, but you don't want to get halfway through your hearing and somebody say, wait a minute, I'm not sure I believe what this guy's saying. I'd like them under oath. That's a good way to lose friends, and so it's easier just to get everybody sworn in up front at the beginning. The statute used to say that the chair to the board had to swear in the witnesses. Now it's clear that the clerk to the board can also, you can have your chair swear folks in, but you can also have the clerk to the board swear folks in, and you can do that as each witness appears. You can do it in advance and have everybody who's testifying come down front. We're going to swear in all 8 of you, and it's like a little football huddle with 8 people trying to get their hand on a Bible to get sworn in at one time. If you have a lot of witnesses, a lot of jurisdictions now have the clerk set up a table at the side before the hearing and say, if you're going to testify tonight, you need to sign in, go over to the clerk, sign in, they will swear you in, and then as each witness comes up, you just ask them, you have been sworn, remind them that they're under oath, verify that as they come up. That saves some time and energy. But it's very useful. It reminds folks that this is a solemn, formal occasion. They're not there to exaggerate. They're not there to make a political point. They are there to offer evidence under oath. And that oath reminds them of the solemnity of the occasion, and is a very important, useful thing. This just makes it a little easier. We had a staff meeting yesterday and talked at some length about subpoenas. This is something we're seeing more and more around the state. The Board of Adjustment can issue subpoenas if somebody wants a witness to appear and that witness is not voluntarily coming, or they want evidence and reports and documents before the hearing, or they want to make sure it's there. You can subpoena documents. You can subpoena witnesses to appear before the Board of Adjustment. The process is somebody who wants a subpoena makes that request before the hearing, and the chair of the board rules on it. If somebody objects to a subpoena, they file that objection with the chair to the board. The chair rules on that. Any appeal of the chair's ruling can go to the full board, but that way the chair rules on it prior to the hearing, and the subpoena is an attorney to a party cannot issue a subpoena. The attorney for a party can request a subpoena, but the subpoena can only be issued by the Board of Adjustment itself, acting through the chair, or if the chair's out of town, you have a vice chair, other delegated member of the chair to do that.
Yesterday, you mentioned that the chair should consult the attorney.
A good idea.
Attorney.
The chair can make this ruling unilaterally without talking to anybody. It would be a real good idea for the chair, when you get a request for a subpoena, to chat with your city or county attorney before ruling on that. It is well worth your time. It's not a long and complicated process, but you probably want to send that proposed subpoena to your city or county attorney, have them look at it and advise you. There are some standards. It has to be relevant testimony, not oppressive, blah, blah, blah. But getting your attorney to look at that would be a good idea. Save you. Better to get it right the first time than try to fix it after the fact. Parties. You were mentioning earlier, this is not always a very formal proceeding. Everybody's not represented by counsel. That is true, but there are parties. The only people who have a legal right to participate in your proceedings are the parties. When you hold a hearing, it's not a public hearing. It's public in the sense it's open. The open meetings law applies to the Board of Adjustment. Anytime a majority of the board is together to discuss business, it's a public meeting. You have to do the public notice requirements for your open meetings. Everything you do has to be in open session. 30 years ago, it used to be common for boards of adjustment to gather the evidence and then adjourn to the jury room, a back room, to deliberate, and then come back and announce their decision. You cannot do that. The open meetings law, everything you do has to be in open public session. But when you hold a hearing, it is not a public hearing that anybody and everybody can say what they want to say. Technically, only the parties have a right to participate in your hearing. So the person who asked for the permit, a person whose legal rights are affected by that decision, and they want to testify in opposition. Those are the folks who have a right to present evidence, to ask questions of witnesses, and so forth. But these are informal proceedings. Oftentimes the folks who are appearing for you aren't represented by attorneys. So you have some degree of informality. And sometimes there'll be neighbors who may or may not technically have standing as a party. The parties are the applicant and somebody whose legal rights would be affected by that decision, differently from the community at large. So if I'm a next door neighbor and approval or denial of this decision is going to affect the value, the use and enjoyment of my property, then I could be a party. But if I live a mile and a half away and I just think this is a dumb idea and I want to give you the benefit of my thoughts, and so I want to appear before you and testify, I probably got no legal right whatsoever to participate in the hearing. Now, most boards will let anybody who shows up testify, and I think that's okay. But if you've got a room full of people that want to talk about something and offer you evidence, and they're not being called as witnesses by any of the parties who do have standing, some local governments are now saying, if you're not a party, you cannot present evidence. You need to be a party or a witness called by one of the parties. That's unusual, but some of our larger jurisdictions are going to that because, I don't know here at the beach, but most towns there are, and you probably know them by name, a small group of citizens who will show up at virtually every hearing and offer you the benefit of their thoughts about whatever you've got on the agenda. And there's no reason you can let them speak if you want, but they have no legal right to participate other than as a observer. They have a legal right to be there, to watch it, to videotape you, but they don't have a right to speak at one of these hearings unless they're a party or a witness called by a party. All that make sense?
And it would be the chair's duty to disseminate that and bring it up if he saw fit.
Right. And if you've got a room full, and sometimes you get a controversial project and you might have 50 people who are there who all want to talk. You don't have to sit there for 3 hours and listen to everybody talk. In part, even if they're parties, you can prevent repetitive testimony. Everybody who's going to say the same thing this witness just said, raise your hand. Thank you very much. You do not need to come down front and testify to that. Duly noted, and move on. You don't have to take everything that comes in. And if it's irrelevant, you need to do it. If it's repetitive, you need to stop it. Just because there's a lot of folks there doesn't mean everybody gets to filibuster. Yeah, but the chair rules on that. And if there's a question that arises, as a practical matter, informally, you let most folks say their piece and keep it brief and move on. How long do your hearings normally take?
40 minutes.
An hour? I think our survey stuff around the state says most boards of adjustment, it's 30 to 60 minutes is the norm for a case, which is one reason you could assign a lot of these to city councils, but most city councils don't want to sit there for an hour listening to testimony about an individual case. So they delegate that decision to their boards, which is perfectly fine. But some of these decisions, increasingly, if you get, are fairly high value, high impact decisions. We had one in Chapel Hill, and I hesitate to offer Chapel Hill town government as an example for much of anything. But we had one where the Board of Adjustment had a 3-day hearing, 3 full days of testimony. They made their decision, it got appealed to court, and the Superior Court remanded it back to the board for additional fact-finding on a hearing. So getting these, sometimes you get these hearings that will last 6, 7, 8 hours of testimony. They get continued. I shouldn't say that. Everybody will be resigning from the Board of Adjustment if I'm not careful. But an hour or so is the norm.
Are you saying that may have not been necessary had the proceedings been handled differently?
No, this was a really big special use permit case for a big project. It was something like 1,800 housing units and 500,000 square feet of commercial space that was located adjacent to a golf course community where the average home value is probably $1 million up. And I think about half of the law school faculty were residents of the neighboring subdivision who were adamantly opposed to this new project coming in to their neighborhood. So all these professors decided they wanted to practice law all of a sudden and present witnesses and cross-examine. The town attorney called me and said, I've got 6 attorneys who all want to cross-examine the same witness. How are we going to arrange it? So that's sort of an unusual situation. But with all that legal talent there, it still got remanded for additional fact-finding. They still didn't get it right. Just goes to show that
So how'd that turn out?
the permit ultimately got approved. If you've
Yes, it
been to
did.
Chapel
Very
Hill,
nice, very nice addition too.
the Meadowmont project,
Yes.
if you come up 54
Very nice.
coming into town, over on the right-hand side of the road, it's it's there, it's built, it's there, and everybody loves it now. But when it was, the opponents back then were referred to it as Meadow Monster. And it was just too big. It was an old dairy farm that got converted to a mixed-use development. And the neighbors, the Oaks, this is the subdivision next door, did not like it. They did not win. They spent a lot of time and energy fighting it, but ultimately it got approved.
Are their houses still worth $1 million?
Yes, yes. In part because the project itself is very, I rode by there, there's a townhouse in the new development. I said, well, that looks like a nice, I'm getting old, maybe I should sell my house and move to a townhouse. It was on the market for $1.2 million. As a little townhouse in the new, it is not a.
So you bought 2 of them?
Yeah. I used all that, the raise we state employees got to devote to my second home at Meadowmont. Yeah, right. Okay, that's parties. Attorneys. When you have attorneys appearing before you, I do not want to speak ill of my fellow attorneys, but you occasionally get an attorney who will show up and say, I'm a lawyer, I don't need to be, I'm going to explain all this to you so you can approve this thing. A lawyer's role of these hearings is to be a lawyer, to advise their client, to maybe ask questions, to present witnesses, to ask questions, to cross-examine. If you have a lawyer who actually wants to present factual information to you, then they are a witness like anybody else and would need to be sworn in as a witness to present testimony. But if they're just lawyering, if they're just asking questions, summarizing the evidence, presenting an argument to you, they don't need to be sworn in. The State Bar Association has said if you are appearing at a quasi-judicial matter to represent somebody, you need to be a lawyer, because that is the practice of law. There are a lot of surveyors, engineers, who think, part of my service to my client is to present their information, to ask questions of witnesses, and so forth. If you want to allow that, you can. I can just tell you that the State Bar Association would say that's the unauthorized practice of law, and that if you are presenting information, questioning witnesses, presenting summaries in a quasi-judicial proceeding, you need a law license. That you can wrestle with on your own. Yeah.
Yet staff's supposed to present.
And there's nothing wrong with the staff. Yeah, but when the staff presents information as the staff is saying, here is the application, you're presenting facts and your analysis. If the staff wants to say, now, when we think the appraiser for the applicant is wrong, and I want to cross-examine the appraiser, the witness for the applicant, and ask them questions, that starts getting into probably where the staff ought not to go. Ought not to go in my role as a lawyer, I tell you, that's starting to edge into the practice of law. And if you're advising the board saying, well, they can't ask that because that's irrelevant, incompetent, immaterial evidence, you sound like Hamilton Berger, who did used to make that objection every Saturday night, and every Saturday night lost. But, yes.
Should the Board of Adjustments have an attorney separate from the town?
I pause because two things. One is if the attorney is advising the staff and also advising, and the staff is actively participating in the hearing, and then also advising the board that makes the decision, that presents a potential conflict of representing one of the parties to the hearing and the decision-making board, and that would be a conflict. So for the most part, the attorney has to choose, am I representing the Board of Adjustment or am I representing the staff who is appearing before the Board of Adjustment? Most of our larger cities have separate counsel for the Board of Adjustment. The city attorney represents the staff and advises the staff, and then a separate attorney advises the Board of Adjustment who is ruling on, because the staff is a party often in those proceedings. We did some survey work a couple of years ago on this, and 90% of the cities and counties in the state have one attorney. Their town attorney represents both the staff and the Board of Adjustment.
Really?
Really. So 90% of the jurisdictions do not have separate counsel. That's 5 or 6 years. I think that's changing, and it used to be just the big cities had separate counsel. But as these cases get more and more adversarial, then you get more and more to, then we want our staff to have good legal advice. And the reason most times the attorneys, there's only one attorney, is because the attorney's only advising the board, or not advising either one. I mean, in a lot of small towns, the town attorney, the town staff doesn't call the town attorney and ask for advice. The town attorney is not at the Board of Adjustment meeting, and the town attorney sometimes only knows there's a problem when they get served with the suit 30 days after the Board of Adjustment has made a bum decision. Oops. And the town attorney is saying, I wish you folks had called me ahead of time. I could have saved you some time and money on this.
David, I think also about the time that the bar came out with the quasi-judicial proceeding practice of law opinion, that it also came out with an opinion about advising staff but not being there to represent them, and saying that attorneys shouldn't do that. So I think that's created more of a breakup between having a board attorney and having a staff attorney, because what would probably happen in the past would have been someone would advise staff outside of the hearing, this is how you do it, and then come to the hearing and be the board attorney. But now they have to, if they're going to advise staff and staff's going to do something, then they need to be at the hearing to guide that process and sit with and be with the staff. So I think that's probably another reason driving the separation.
And typically it is, I would advise, my personal advice, not a legal requirement at all, but just my personal advice is I think you should always have, the board should always have an attorney advising the board at the meeting. It is worth your time. It's sometimes expensive, but it's the old ounce of prevention sort of proposition. So a question might come up: is this relevant testimony? Is this substantial evidence? Can we consider this piece of evidence? And those are often legal questions, and it's useful to be able to pause and ask the attorney to explain that at the time, to take a brief recess and consult with your attorney for some legal advice. And if you, sometimes in 2 or 3 minutes, you can get something right that will save you having to go back and do the whole hearing all over again after the fact. So it's, again, that's personal advice, but I think it's generally money well spent to get good legal advice either up front prior to the hearing or during the hearing. And I say that just not because I'm a lawyer and looking for business for my fellow counsel, but I think it's good service to the board to get that kind of assistance as you need it.
I had a question. So
yes.
Back to the role of an attorney. if you have an expert witness that's coming up to testify, what is it? I mean, is it the cross-examination piece, or where's the line cross where they're practicing law, for instance? I mean, if you have an applicant and they have surveyors and they're coming up and offering, based on their credentials,
Absolutely.
you know,
Yeah, that's fine. A witness can always testify as to the facts, and they can present their credentials, they can present their factual information. So that's all fine testimony. What you want to be careful about is not have the surveyor then ask the questions of the appraiser. Or if you have dueling engineers or dueling appraisers, is one asking the other questions, that's where you get into problems.
okay.
I'm not sure that's responsive.
It's kind of a tricky area. I mean, you know, sometimes those things kind of develop. You just for us to try and be aware of them. But
And we'll talk about, we'll take a break here. We'll finish this, anything with attorneys, then we'll take our break and come back and talk about other witnesses. But expert witnesses, since we're on this point, let me just mention a quick point about that. For the most part, people offering you testimony are just offering you factual information that they either are based on their personal knowledge or they've prepared a report, an analysis, or they know the situation, they're offering you evidence and facts. There are two areas where opinion testimony can only be offered by an expert witness. And that is the public safety impacts of traffic and impacts on property value. So a neighbor who shows up who is not an appraiser, not a real estate agent, has no expertise other than the fact they're a neighbor, and says, everybody, in my humble opinion, this is going to ruin my property value. You cannot take that and base your decision on the opinion of the neighbor who thinks it's going to hurt their property value. If you're looking for opinion testimony, it can only, on property value impacts, it has to be offered by an expert witness. And so, to be an expert witness, the person's got to present their credentials. You know, here's my education, here's my experience, here's why I'm an expert. Plus, they then have to testify as to the foundation of their opinion. I have done this kind of study, I've looked at these comparables, this analysis, and then get to and in my professional expert opinion, this will have a 5.7% reduction in the neighboring property value in the first year. And they can offer, you can rely on that opinion provided A, they're an expert, and B, they've given you a proper foundation for their testimony. So the only reason you need expert witnesses is to get opinion testimony on basically those 2 points. And anything else that an expert witness would be required in court, but anything else rarely ever comes up before the Board of Adjustment. It's usually public safety impacts of traffic and property value.
But at that point, if you have the applicant and you have their surveyor and you have their neighbor and they've all been sworn and they're all providing their testimony and there's not an attorney in the room.
Right.
Who can ask that person a question? Anyone other than the board?
Cross-examination as a practical matter is almost always done by the board. The board members themselves can ask any witness a question. Could you elaborate on this? Could you explain that? Most of the questioning is done by board members. The only other person who has a right to ask questions is a party. So that's where you have, and since you haven't formed, and it's not like a courtroom where you have, you know, the plaintiff on one side and the defendant on the other, and they're clearly identified parties. If you have a citizen, the applicant is always a party. So if the neighbor presents testimony, the applicant can ask the neighbor questions as cross-examination. If the next door neighbor is almost always going to be a party, and they want to ask questions of the surveyor or the engineer, they have a right to do that. But if a member of the audience, you know, raises their hand in the back of the room and says, I got a question, you need to be careful about that. Because if they're not a party, they don't really have a right to cross-examine the witnesses. But one of the legal rights, due process rights of a party, is the right to present evidence, to present rebuttal evidence, and to cross-examine all witnesses. So you've got to give a party the opportunity to ask questions of any witness. That's a requirement. If you said, no, only the board can ask questions, that's one of those things that you should not do. It may be a quaint practice, but it is illegal. You cannot restrict questions to only coming from the board.
Very good point. My question is, can you share maybe what's the response for our zoning board or our zoning board chair when this happens, when you have two real estate appraisers cross-examining each other, or two surveyors saying, well, no, that I disagree with your surveying technique and you're 200ths off, or whatever it is. What would be the zoning board chair's proper response to that, or who would make that response?
My guess is the zoning board chair should say, excuse me for a moment, I need to talk to my attorney. And you need to have a quick chat, and then, there's nothing illegal about the one surveyor asking the other questions. And the question is, do you want to allow that or not? It might be technically the unauthorized practice of law, and you might do that. But you also want to be careful not to cut off somebody's rights to cross-examine a witness and have a party ask it. So some degree of informality is allowed. But just how far you go in that's where I would think you'd be somewhat contextual in the exact who's asking what, about what, and a level of detail that I think it would be advisable for the chair at some point to allow you're better to allow a little bit to come in and allow the process to continue, but you want to keep it manageable and under control. And when you cross that line is a good reason to have your attorney present and ask about, in this particular context and situation, should we cut this off or allow it to continue on? What do those of you who advise boards think about that?
Sounds good to me.
I'm advising to cut them off.
It's a misdemeanor in North Carolina in practice.
Yeah. What would you advise them?
The only time it's only come up a couple times with someone who I thought really crossed the line, and I advised the board, as the bar requires, that the person's crossing the line and that they may be breaking the law, but the bar opinion says they can hear it if they want to, and that person just takes it's at their own risk whether or not they get charged with a criminal offense by whoever's going to charge them. I don't know who exactly would do it, but I think the board can hear the evidence if they choose to, but the attorney does have the duty to advise them that that opinion is out there.
If there is an attorney to the board, would the attorney be good to advise the chairman in case the chairman doesn't realize what's going on, to kind of?
Yeah, I mean, as a member of the bar, you have an obligation to advise your board that somebody is doing something inappropriate. Your duty as an attorney is to tell the board that. Whether the board does anything about it is up to the board. So ultimately, the decision is with the chair to the board to make a ruling on that. But most folks, you say, as long as you rein it in politely, discreetly, respectfully, it's usually not a problem. I mean, you don't want to be heavy-handed about it, but you also don't want, part of the job of your attorney is to keep you out of trouble and to help you avoid problems. And that's one of the ways you do it. All right, well, let's take a 10-minute break, and we'll pick back up and wrap up after that.
Stand up.
Let me run through a little bit more on the how you conduct your hearings, and then we'll talk some about appeals and variances, the particular aspects of that as well, and still be out of here by 11:30. Some of this we've already talked about as we went. Witnesses under oath, cross-examination, Any questions about that? Thoughts about that? Yes, sir.
Sometimes when you go to put somebody under oath, they have reservations.
Yes.
About it. And so the standard is, as you said earlier, you swear to tell the truth, the whole truth, nothing but the truth, God. Some people don't want to say,
Right.
God. So is it okay just to cut off that line?
Yes.
Under God? Okay.
Yes.
Some people say,
Anybody who has religious objections to an oath can do an affirmation instead. Some boards just do that automatically. Some use a Bible. Some say, well, we don't want to get into that, and then we'll just cut it off. But you do need tell the truth, the whole truth, and nothing but the truth.
That's what we do.
Either period or, yes, but that's perfectly fine. Outside evidence. Parties to a decision, one of the legal rights they have, one of the due process right of any party is to hear all the evidence and to cross-examine witnesses. If you are gathering evidence outside the hearing, you're talking to the applicant, you're talking to the neighbor. The other parties don't have the opportunity to hear what they're telling you. Your fellow board members don't have the opportunity to hear that evidence. There's no cross-examination. The courts say don't do it. So if somebody calls you up on an evening, Saturday afternoon, and wants to talk about, I'd like to come to the hearing and testify next Tuesday night, but I'm going to be out of town. Let me just tell you a little bit about this. You need to politely say, I'd love to spend my Saturday afternoon talking zoning with you, but the law doesn't allow me to do that. I can't discuss the case, can't gather any evidence outside the context of the hearing. So if you're in the line at the grocery store, if you're at home on Saturday afternoon, don't talk about the case with anybody else. If they raise it, sometimes people start talking with you. You're at a civic club meeting, you're at church on Sunday or whatever, and somebody starts talking to you about a case and you don't even know it's about a case until you're 3 or 4 or 5 minutes into the conversation. It doesn't automatically disqualify you or anything, but you need to, as soon as you understand that they're talking about a case that either is or may be coming before you, to politely, discreetly let them know that you really can't talk about this case outside the hearing. Come to the hearing, present your information, we'll give you a fair, respectful decision, but I can't talk to you about this outside the context of the hearing.
Would that also go with staff, if you had staff?
Yes. Now you can ask staff background questions. If you want an explanation of, well, what is this ordinance requirement? Tell me about the ordinance outside the context of the particular case. You can always ask staff that kind of question. But if you want to talk to staff about the case, this same rule on outside contact applies. Wake County used to have the practice that they thought was a really good practice of big county. They would have 4 or 5 cases every month. And their standard practice was for the Board of Adjustment to meet the day before the hearing, and the county would have a van, and the county staff would drive them around to do a site visit of all the cases that were coming up the next day. And the staff would also generally give a running commentary about the case as they drove by and stopped and looked at them. And you say, well, boy, that's great public service. But, you know, picture yourself, you're the applicant. You see this van full of people riding by and the staff person's in there. You see their mouth moving, pointing. What are they telling this board? They have a right to hear that, to ask questions. So the staff can't do it. Now, individual members, if you want to go look at a site ahead of time, that's perfectly fine. Some boards will all ask the staff to do photographs, to do videotapes, that sort of thing, and enter that into the record, which is fine. But if you want to look at a site, or if you have personal knowledge about a site, it's perfectly fine. People are not put on boards of adjustment at random. The city council doesn't go through the phone book and pick 5 random names and say, let's put them on the Board of Adjustment. You may sometimes feel that's how you got there, but boards, you're picked and chosen because you know something about the community, you're active in the community. You may be active in real estate or development or historic preservation or neighborhoods or community service of one sort or another. A lot of times folks are long-term residents, they know the people, they know the situations, and that's perfectly fine. But if you have personal knowledge that you think is relevant to a site, you know, I know that site. I've been driving by it every day for 30 years, and I know every time it rains more than a quarter of an inch, it floods. And that's relevant to our case. It's perfectly fine for you to bring that personal knowledge and experience to bear, but if there are facts you know, you need to say it out loud at the hearing. While other people, so the applicant say, well, wait a minute, you're confused. It used to flood, but we've added a culvert and it never floods anymore because we put this culvert in just now. So you give them a chance to refute that. But if it's evidence you're relying on and making your decision and it's based on personal knowledge, the tip is to be sure to say it out loud at the hearing so it's a part of the record, that the other board members know it, and that the applicant and the other parties have a right to respond to that, to rebut it if need be. But personal knowledge is okay. A little bit of outside contact is okay. How undisclosed outside contact is a kiss of death. If you have talked to an applicant inadvertently, before the case even came up, you had a half-hour conversation with the applicant, and it turns out midway through the hearing, it dawns on you that this sounds familiar. I've heard about this before, and oh yeah, I had this conversation last month with the applicant or the neighbor. Say that out loud, disclose that at the hearing. Say, I had a brief conversation, I didn't learn anything in that conversation that hasn't been presented tonight. Undisclosed outside contact is where you're in trouble. Where you get into big trouble is if you're then asked about it and you say, oh no, I never had that conversation. And it turns out you did have that conversation, then things go south in a big hurry. So if you've had some inadvertent or modest contact outside information, disclose it at the hearing. We talked about this a little bit earlier. Hearsay testimony is if somebody is offering evidence to establish a fact and the person is not present, that's a problem. Some degree of hearsay you can take. And our courts have said, for example, a letter. You get a letter from the DOT district engineer that says this meets state standards. Assuming that it's not a clear forgery, you know, somebody's got, you know, the wrong governor on the letterhead or something. If it looks reliable and it's an official government document, you can accept that as evidence even though the district engineer isn't personally present to testify about it, or you get a letter from the FAA or something like that. But if you're offering it as evidence and to establish a fact and somebody does have a question about it, then you need to continue the hearing and bring in a witness who can answer that question. And if it's an unresolved question, you can't get somebody to testify about it, then you shouldn't consider that piece of evidence. And if it's on a critical contested fact, you need to make it clear that you're not relying on that outside evidence where there's no cross-examination. If it's just a routine letter that's in the file and it's undisputed and uncontested, then fine. Go ahead and do it. Any questions about that? We already talked about opinion testimony. Anybody can offer you facts. The example from a Court of Appeals case on traffic safety. If I'm the neighbor, and one of the issues is the additional traffic from this project going to be a safety issue? If I'm the neighbor and I show up and I say, everybody knows this is going to be a traffic problem. You cannot rely on that. In my opinion, this is going to be a traffic problem. You cannot base a decision that this will cause a traffic problem on my personal opinion, unless I'm a qualified expert witness. However, if I'm the neighbor and I come and testify that the access road leading to this project is only 12 feet wide, I sit on my front porch and a school bus stops every afternoon and drops off 8 or 10 kids who walk down this little 12-foot wide paved road, and this project is going to put an extra 140 trips per day on this pathway, and that's, I think, a safety problem. You can take as factual testimony, it's a 12-foot road, there's a school bus, there are kids on it, there's no sidewalk, there's 125 extra cars a day, and then you can make the conclusion as a board that that's a safety problem, because you've got facts offered by a witness that allow you to make that determination. The neighbor doesn't have to be an expert witness to tell you what they see with their own eyes. And you can make logical conclusions based on that factual evidence. So a neighbor who comes in and says, this is going to hurt property value, they need to offer you more than their opinion. And it's perfectly appropriate as a board member to say, why is it going to hurt property value? What do you base that determination on? And it needs to be more than just their opinion. Because I used to live next door to, well, it's hard to do an opinion testimony. Well, factual testimony about property value is just hard, unless you've got comparables and some good, hard, empirical data. But traffic safety, facts are important, and you can get those from anybody. Anything about opinion testimony? Especially with special and conditional use permits, one of my favorites was Raleigh required they wanted to redo their standards for adult business locations. And the city directed the staff to look at the First Amendment issues, come up with as strict a regulations as possible on location of adult entertainment establishments, and the staff worked on it, spent a year doing their standards and had all the separation requirements and limitations, and adopted it and required a special use permit for these. And the first person in the door asked for was an adult bookstore, and applied for the special use permit. And in Raleigh, the city council did the special use permit decision. So they held the hearing on it, and the applicant showed up and had 3 witnesses, all to say, we've gone through the standards, here's our studies on the separation requirements and the technical aspects of meeting this. And as you might guess, there was nobody else there other than the applicant's 3 witnesses to testify how it did meet the standards. I don't know how adult businesses stay in business, because nobody ever comes to the hearing to say, we need more porn in the neighborhood. There's usually a room full of folks who are opposed there. And in Raleigh's case, there 60 or 70 people were all there saying, and this was in a small, what's the term for, small commercial? Strip mall. Yes. So this I wasn't going to say it, but so all the neighbors were there, and the neighborhood behind it, the ministerial association was there, and they were all there to say, this is just bad, this is terrible for our community, it's degrading to women, it's a bad environment for children, we just don't want this kind of stuff in our neighborhood. And people with the stop signs pinned to their lapel and the whole set. And you got like 60 or 70 of these folks before the elected city council, and their testimony all was, we don't like it. We don't want it in our neighborhood. Is that evidence as to whether or not this meets the standards for the special use permit? No. What do you think the city council, faced with 3 out-of-town experts saying it meets all the standards?
Was it an election year?
Isn't it always an election year? This is when you hate to be the city attorney. And I'm not making this up. may exaggerate a little bit, but not much. One of the council members, and this is where you really hate to be the city attorney, I felt bad for the city attorney. One of the council members says, well, this may meet all the standards in the ordinance, and some judge may issue this permit, but I'm never voting for this sucker. I make a motion to deny the application. It was, I think, nearly unanimously adopted, and the mayor discreetly told the city attorney, when we get sued, settle it quickly and issue the permit, but we aren't voting for this in an election year. But the fact that all those people were there offering you the opinion that it was bad is irrelevant to the decision as whether or not it met the standards. And if it met the standards, they're entitled to their permit. So I just thought it was funny. You just, as the lawyer, when the person making the motion to deny the permit says, it may meet all the standards in the ordinance, but, you know you're in trouble.
They in fact set themselves up for that.
Yeah, and it was not a profile in political courage, but such is life. Documentary evidence, written material submitted. One of the requirements, and I think I've got a slide later, which I'll skip when I get to it. Let me mention it now. One of the new requirements in the statute is that the record for an appeal that's made to the board, you send a copy of the record, the application and any documents and supporting material to the board prior to the meeting for the board to look over and read, but you also have to send a copy to the applicant. So the applicant gets the same material that goes to the board, so they know what's in front of them, so they can prepare for the hearing ahead of time. If anybody does bring you documents that they want you to consider, let them know that if you're going to consider it, they have to submit it. It becomes part of the record. You should put a little sticker on it with its, Exhibit 23A, and keep it in your record. So if somebody brings a nice, big, glossy color photo and says, I'd like to show you this, but it's expensive and I'm using it for marketing and I can't leave it with you, then you cannot take that as evidence and tell them to turn it over, take it off the easel and put it away.
Do you have any recommendation as to when an applicant brings evidence or presents evidence at the hearing and says, I submit this for your consideration?
Yeah, if they want to present new evidence for you or bring you materials, that's fine. Do some record keeping. Whoever's staffing the board needs to label it. I mean, it's terrible when you're trying to remember 30 days later or 6 months later which exhibit were they talking about. I would get the little package of stickers that have numbers on it and put a sticker on it and say exhibit 1, 2, 3, 4 or whatever, so that you label it, submit it for the record, keep it in the file. It becomes then part of your official file for the case. But yeah, people can present documents at the hearing. If they do a photograph, I mean, you don't need to be overly formal, but it's always good to ask, well, who took this picture? Get them to testify that it accurately reflects the conditions that I saw at the time, and that sort of thing, to sort of establish the provenance and reliability of the particular piece of evidence you're getting. Now, if somebody shows up and says, I found this on the internet last night, and I think it's, that kind of document I'd be a little careful about taking as an exhibit.
And if it goes around their cell phone with the photo to the board?
No. Unless they want to leave their cell phone with you as an exhibit, I would not let them do that. If they want to print a picture off and introduce a paper copy, they can do that. But passing around the photo, well, he raised this question, let me show you that's not true. I got a picture to show it. No, not unless they're prepared to leave that with you and make it a part of the record. Role of the chair. The chair explains the rules, maintains order, decorum, keeps things moving. If there's irrelevant testimony being offered, the chair has some obligation to keep things in the proper bounds. If you are chairing one of these boards and you need to consult with your attorney, that's perfectly fine. Take a recess, pause for a moment. Sometimes the attorney's perfectly willing to answer the question out loud. You can just pause and say, well, let us ask our attorney for some advice about that. Sometimes the attorney might prefer that you take a recess and they give you that advice individually. Talk to your attorney, see how they want to handle that sort of thing. If there are motions made, this is irrelevant. The chair rules on that. Somebody can appeal the chair's rule to the full board. On any matter, the chair says, I think this is irrelevant. The person could say, could we get the board, does the whole board agree with that? And the whole board would then vote. You could appeal a chair's ruling to the full board. Pretty rare, but you can do it if necessary. Board members, be there, be present, be prepared, be attentive, be respectful to the folks who are testifying. I've only seen this happen once, but I did see one, and it was on videotape. The board, somebody's presenting evidence, and it was clear that the board was not paying any attention. They were talking amongst themselves, reading the cell phone. One member got up and left during the testimony, wandered out to get a cup of coffee or go to the restroom or something, and came back. It was very clear that the board was paying no attention whatsoever to the testimony being. If you do that kind of egregious thing and you get appealed and the court looks at the videotape, you're going to get smacked. The proverbial 2x4 will come out to hit you up with it. But, you know, sometimes you have to be there a long time listening to stuff you'd rather not hear. Well, that's your job and role as a board member, is to respectfully do that.
Our relevancy in terms of, you might have a question or a board member that wants something that they feel is relevant, but it may be relevant to the issue, but not to the case. And I'm trying to get down to how important is it that it's relevant to the case and to the actual the actual decision that you're making, because I see a lot of information coming in that it's peripheral, but it's not relevant at all to the decision that they're asked to make.
Yeah, I think, you know, common sense, rule of reason, something like that. I think it's fair to sort of, you know, I need a little more context. I'd like some explanation of the rules, how did we get to where we are. A little bit of that is fine, no problem. But the judgment call is, when are you getting off track? And the chair, that's one of the roles of the chair, is to make sure that, you know, this is an interesting discussion, but it's really a broader issue. And, you know, if you're doing an appeal of an interpretation on computing the area of a sign, and somebody wants to ask a little bit about, you know, the background of the sign ordinance, that's perfectly fine. But you don't want to go off on a tangent about other signs that were somewhere else in town 4 years ago, and how is that different from this case? I mean, you want to keep it somewhat focused on the case at hand.
Well, why the sign ordinance was done that way.
You're right. Yeah,
It's not relevant to the issue of.
Yeah, the board has to make its decision based on the ordinance in effect today and as it's written. And if you want to have a broader discussion about why is it written this way and how should it be different, that's a discussion for another day.
And that brings me to another question, is, and I'm sure some of the other people have similar experiences, but our board oftentimes wants to know, well, how did it get that way?
Right.
You know, was it a building inspector that's dead, or, you know, a previous planner, or is it somebody that's working in the shop today? And is that relevant?
A little bit, sure. A little bit of background on how the ordinance came to be, what it is fine. But I wouldn't do too much of that.
Can we step back a screen? Are we finished with the screen? There, the first one, the role of the board chair, explain the rules.
Yeah.
I've seen a it's probably a paragraph, or maybe 2 paragraphs, that more or less says this is the Board of Adjustment, this is what we do.
Right.
What is your opinion of maybe reading that as an opening statement at the meeting and take some of these situations, in my opinion, to the side? Okay, this is not what they do. They are
Right.
not executive. They are not legislative.
Yeah. I think
What
that's
is
an
your opinion?
excellent idea. My recommendation is have a piece of paper that you give to the applicant when they do their explanation. If the neighbor you know is going to want to testify, have a piece of paper that explains that. I think it's also a good idea to do the 2 or 3 minute summary at the beginning of the meeting. I had a lady call me and said that the staff told me to call you in Chapel Hill or ask this question. And that's always a bad sign. If some citizen is calling you because somebody at the town, they were upset about, it was a voting issue. This was a citizen who wasn't being allowed to vote on an issue in Charlotte. It was an electoral campaign, and I had no idea why they were calling me, and I'm still not absolutely certain why they were calling me, because election law is not my field of work, but they were upset because they weren't being allowed to vote in the Charlotte City Council election.
Do they live there?
Well, and as we went into the conversation, it turned out they lived over in Union County, and when that came out, I said, well, ma'am, the reason they're telling you can't vote is because you don't live in Charlotte. And her response was, but I work there, I drive in there every day, and this is a real problem, and I've got important concerns about their development patterns and what they are and aren't doing. I mention that to simply say that you're dealing with folks who sometimes aren't sure what jurisdiction they live in, much less whether this is quasi-judicial or legislative, or whether the city does it or the county does it. So I think a short explanation, this is the nature of what we're doing, why we're doing it, we're only listening to relevant testimony. These are the 4 standards, information, facts about these 4 standards are what we are looking for tonight. I think that's very helpful. And anything you can do to help citizens, I think most citizens want to participate effectively and fairly, and the more help you can give them to make sure they do it, the better off. Let me say this and then jump over to some of the specific things. I want to be sure we get to variances and appeals. But I also don't want to skip impartiality. And this is sometimes awkward. Almost everybody, and I say almost everybody, I've run into 1 or 2 exceptions, but almost everybody that is on a Board of Adjustment wants to do the right thing. They are fair, they are reasonable, and they want to do it right. But one of the things you have to be very cautious about is that the parties appearing before you have a right, a constitutional right to an impartial decision maker. Unlike the city council, if you're presenting a rezoning petition and you're either for it or against it, you don't have a right to an impartial decision maker. People run for city council because they want relaxed rules for commercial development, or they want more protection for neighborhoods, or they want this, that, or the other. Impartiality in an electoral legislative context is not required. But when you get to the Board of Adjustment and a quasi-judicial decision, you have to have impartiality. That's one of the legal constitutional rights the parties have. That means if you have any financial interest in the outcome of the case, you must not participate in it. If your wallet would be heavier or lighter based on that decision, you cannot be a party to making the decision. If you have a close business, family, or associational relationship with one of the parties, the fact that you can set that relationship aside and vote fairly doesn't matter. Because picture yourself as the person who loses. And if they have a reasonable grounds to wonder, was your decision based on the merits of the case or your relationship to one of the parties, then you violated their rights. They don't know. whether you were able to do that or not. And whether you can do it or not doesn't matter. If you have that close relationship, you cannot participate in the decision. I was doing a board training once with Board of Adjustment, and somebody said, well, wait a minute. Small town. My church applied for a side yard variance for the new education building. Are you saying I shouldn't have voted on that? I said, well, maybe if it's one of these, big mega churches that has 1,000 members and you go once every other year and they slap a visitor's tag on you when you show up, maybe it was okay. I said, oh, no, I was chair of the building committee and chair of the Board of Adjustment. Well, friend, in that case, you should not have voted or participated in this. And very importantly, if you have one of these close ties, it's not only abstaining from voting, you can't participate in the deliberation, in the discussion, in the examination of witnesses. My advice to you is get up and leave the room. Walk outside, get a cup of coffee, have somebody call you when it comes back. That's why you have alternates on the board, not only for your absence, but if there is a conflict, somebody else can sit in for you. And you just absent yourself, but don't participate. I say absent yourself because if you're standing in the back of the room and somebody's testifying and you're sitting there, it's hard to avoid the facial expressions, the body language that maybe some might think trying to influence your fellow board members.
Being the small town that we are, having a relationship with someone that might come to the zoning board is likely.
Yes.
Where is that line drawn? Are they a member of your Rotary and that's too close? Or if they're
having some
you used to be
casual
their college roommate,
Sure.
and you're their
It's a judgment call. Each one's a judgment. Knowing the person is not a problem. Being distantly related to them is not a problem. My family, if I were on the Board of Adjustment here in Dare County, my family from the early 1700s, Dare and Currituck County is where all my relatives are from. I'm probably related to if they've been here more than 20 years, I'm probably related to them somehow. But that kind of distant relationship doesn't, if it's a second cousin twice removed, fine. If it's your spouse, a member of your immediate household, no. If it's somebody you shop with occasionally, you're a member of the Rotary Club with, no problem. If it's your accountant, your personal attorney, somebody you have a really close business relationship with, your business partner, then no. But you have to sort of make that. The test is, would a reasonable person have a reasonable grounds to wonder whether your decision is based on the merits of the case or your relationship with one of the parties? And my advice, when people call me on the phone and say, let me describe the situation, and you tell me if you think it's a conflict, I usually cut them off at that point and say, if you're worried enough about it to call Chapel Hill and ask, then you probably got a conflict before I even hear the details. Because if you're worried about it, think about the person who doesn't know you, doesn't know your personal integrity, and maybe on the losing side of a case, they may also, and if that person has a reasonable grounds to be worried, then you shouldn't participate.
Okay. Not to supplement what you're here, but can I just say how we deal with it, or I deal with it? Whenever someone comes up in our small town, as Meredith says, I disclose if I know the surveyor or the attorney or the applicant or their children. I tell everybody
Sure.
right up front. I said, if the board has a problem with it, please vote if you'd like me to be recused. And then then the board all knows, everybody in the audience knows, they have an opportunity to object right then. And they can't say, I didn't know.
Right. I think that's a good idea. If you have a relationship, I would disclose it. The individual, if you want to talk, that's a good thing to talk to your attorney about ahead of time. This is a close call. I'm not sure about this. This is my sister-in-law. Should I do this or not? A good idea sometimes to ask your attorney in advance about that, to disclose it. You have to make ultimately, responsibility is the individual board member makes the call. If somebody objects, if you say, here's my relationship, and I think I can set that aside, and it won't influence me at all, and I'm willing to vote on the merits, and one of the parties objects, then the rest of the board votes on whether or not you stay or go for that particular case.
Thank
Anything else on conflicts, impartiality?
Just on conflict of interest, is there a general statute definition that's a little bit different than this?
Not much, no. This is on legislative matters. If you're a member of a planning board or city council, the standard is, would you have a direct, substantial, readily identifiable financial interest? That's the only thing that disqualifies you on a legislative matter. And it only disqualifies you from voting, not from participating in the discussion. But it has to be direct, substantial, readily identifiable financial interest. That disqualifies you in a legislative context. When you move over to the quasi-judicial context, the statute says, which reflects case law, that the parties have a right to an impartial decision maker, and due process requires you to be recused if you have a financial interest, a bias or fixed opinion, undisclosed ex parte communications, or a close family, business, or associational relationship with one of the parties. So that is sort of a paraphrase of the statute. A bias, you might have some opinions about it, it's fine. A bias is if a reporter calls you the day before the hearing and you say, I don't know what those suckers are saying tomorrow night, but I got appointed to this board to prevent this kind of crap in our community, and I'm voting against this sucker. You can count on that. Put it in the paper. You have just disqualified yourself from any, my mind's made up, don't confuse me with the facts. That's what the court means by bias in this context. I know you would not have that kind of bias, but if you do, keep it to yourself. Your decisions, last point, I'm going to then skip to appeals so we get to that. This may be a change in the way some of you do your work. This is part of the new statute, is your decision has to be in writing, must clearly resolve any contested facts. Party A said this, Party B said that. What did the board conclude the facts were? You're acting much like a jury in that context. You decide what the facts are, and your decision needs to reflect what you thought the facts were, particularly for any item that has been contested. So if people are arguing about is will or will not have a property value impact or whatnot, the board needs to make sure you have discussed before, don't just vote. Somebody gets tired at the end of the night and they say, I've heard enough, I move approval, quick second, all those in favor, boom, we're out of here. You need to, in your deliberations and your discussion, make it clear what the board thinks any contested facts, how they should be resolved. So that whoever is writing up this opinion for the chair to sign knows the basis for you reaching your decision. Some boards have drafts prepared ahead of time so that you can, I make a motion, we approve the findings and conclusions as proposed by the applicant. That's perfectly fine as long as the evidence is in the record to support what the draft you had in front of you. Some ask their attorney to draft up the order after the hearing or the staff to draft that. That's fine too, but the person drafting it after the fact needs to know how you resolve contested facts and how you arrived at your decision. So you need to take care to give the staff sufficient direction, give your attorney sufficient direction that you can get that accurately done. Has to be done in a reasonable time, sign it in writing, and it's effective when you file it with the clerk to the board. So you file your written decision with the clerk to the board, and when you file it, you then mail a copy to you can deliver it, personal delivery, email, or first-class mail. The person then has 30 days to appeal that decision, and the 30 days starts to run from the time you filed it, so the clerk needs to date stamp it. If you use first-class mail to send it, you add 3 days to the date you dropped it in the mail to the time they have to file their appeal.
Can you talk a little bit about options for the board when they get to the end of the meeting and they don't feel like they have enough evidence, or that contested evidence hasn't been sufficiently resolved? What are the options for the board there about either continuing the meeting
Sure.
or?
Probably if there are questions that come up during the hearing you would like more information on, more evidence, it's always fine to continue the hearing, to say, okay, we've got all the evidence we've got, but we need more information about X, Y, or Z. Staff, would you look into this? Applicant, you need to bring us, this question's been raised, you need to give us some response to this. We'll continue the hearing. You can continue to the next day, you can continue to your next meeting. I would not table the matter, particularly indefinitely, because you have to have, a decision in a reasonable time. So you don't want to put it on hold indefinitely. If you want to continue it to a date certain. Tomorrow night, our next meeting, be specific about what you want. Or if the neighbors are there and said, well, we just thought if we had a whole bunch of neighbors show up, that was sufficient. We didn't know we had to have evidence. We just heard this explanation for the first time tonight, that we got to have real evidence. You don't have to delay the hearing. You don't have to continue. You can't say, well, you had your chance, we're here tonight, you got evidence, bring it on. Otherwise, at the end of the night, close the hearing, deliberate, vote, it's all done. But you have the discretion to say, we would like to continue, we will continue this till next month. Bring us that evidence then and we'll make a decision. Or if you have all the evidence you need, but you just want to ponder it, you want to think about it a little bit. Some boards do that. They take the evidence at one meeting and then they come back and vote at another meeting, and that's perfectly fine. But if you want more information, the board needs to be clear what information they want.
We've had it happen, so I'm gonna ask for the proper procedure, when the person who made application doesn't show up.
You're free to proceed ahead in their absence. You scheduled your hearing, as long as you gave them reasonable notice, you mailed them the notice of the hearing, then you base your decision on the record they submitted. Now, you can continue and say, well, the applicant's not here, we don't want to make a decision in their absence, we will just continue this until next month. Staff call them up and tell them if they're not here next month, we're voting anyway. You can do that. You can continue it. You don't have to. You're perfectly, there was a Court of Appeals case from Currituck. This is a long time ago, where it was continued a couple of times, and like the third time, the applicant didn't show up and didn't present any information. The board voted, and then the applicant complained and said, but, I had more stuff I was going to bring. Tough luck. It was a regularly scheduled meeting. It was continued. You had and I think they had actually maybe called the day beforehand and asked for a continuance, and the board said no. We've had 3 continuances already. We've done all we're going to do. Be there, be square. And they weren't there, and they lost out.
Is it permissible to dismiss the case, say, without prejudice, as opposed to hearing it and then them losing it? What is fair, or what?
If they've got, once they've made a complete application and it's in front of you, then you can make a decision. I don't think you can dismiss a case, and the person can come in, the applicant can withdraw. And sometimes the handwriting is pretty clear on the wall, and the applicant says, whoa, I need to pull back and rethink this. So the applicant can withdraw. But I think the board only has the option to either grant or approve their decision, or to continue it later. I don't know that a dismissal is essentially a denial. So, I mean, if the applicant doesn't have enough evidence to show they meet the standards, you could say, friend, you're about to get denied. Would you like to withdraw your application, or do you want us to go ahead and vote on it? And if they say, oh, in that case, I'm withdrawing, then there's nothing for you to vote on. But if they say, I'm taking my chances and vote on. Now, once the board makes a quasi-judicial decision, and this is an important part of that, you can't come back. It's done forever. There is no wait 6 months and let's try again, or wait a year and try again. Now, on a rezoning, you can come back and ask for exact same rezoning. Sometimes there's a waiting period in your ordinance of a year or so. But in a quasi-judicial matter, once you make a final decision and you vote on it, that's it. They cannot come back unless they bring you unless there's material change in conditions on the site, a significant change in the ordinance, or a different project. They have to materially change their project. They bring you a new application, yes, but they can't come back next month and say, you know, I'd like you to reconsider this. Their only recourse is to appeal to Superior Court, and they've only got 30 days to do that.
There are some dismissals for lack of timeliness and stuff like that. Doesn't matter.
Oh yeah, I mean, if you have, like, if you could dismiss something for, we don't have jurisdiction to hear this. You had to file your appeal within 30 days of the staff determination. It's been 6 months. We have no jurisdiction to hear this. For that kind of dismissal, you can certainly do. If you don't have jurisdiction to hear it, definitely you can dismiss it for that sort of thing. Or if somebody's not a party, you don't really have standing to bring this action, you could dismiss that.
Question about delivering the decision.
Yes.
We send a certified letter to people who are denied, so we have proof that they received it. And that would be the start of their 30 days, well, the date stamp plus the 3 days.
Right.
Say they refuse to accept that. Does the 30 days still start, or
Yes.
say the 33 once it was date stamped, even though they refuse to accept that, or can they prolong their?
That's what.
Yeah, the new statute says it's the effective date is the day it's filed with the clerk, and then the burden is on the staff to deliver the decision. You can email it to them. You can personal service, have the sheriff deliver it. You can walk out and hand it to them, and you can send it first class. You don't have to send it certified, return receipt.
Better to not send it certified.
Yeah, if your own ordinance says send it certified, return receipt, then you've got to do it. This is the new state statute, though, and this is the minimum you have to do. But if you drop it in the mail first class to the address listed in their application and wait 3 days or 33 days, it's done. Yeah, and the whole idea here is to have very clear dates so you know exactly where everybody stands on this. Appeals, let's see. I'm going to skip appeals. I'll come back to appeals if we have time. I'm going to go to variances. Since variances is, I'll come back and say a quick word about appeals, but since we're 11:25, I said this was one of the most difficult things you do, so I saved 5 minutes for just this. A variance. A variance has been in the statute since 1923. It used to say, based on the Standard State Zoning Enabling Act, that practical difficulties or unnecessary hardship resulting from a strict application of the law, and if the spirit, purpose, and intent of the ordinance is observed and substantial justice is done, you can get a variance. The new statute gets rid of the practical difficulty term, which was largely surplusage. In some states, practical difficulties and unnecessary hardship were two different things. In North Carolina, our courts always looked at it as one thing, so now the statute reflects that, and it's just unnecessary hardship. Practical difficulties is gone, but it didn't really mean anything anyway. The statute codifies a couple of standards for what constitutes unnecessary hardship. it must be peculiar to the property. If there's a situation that is based on the personal circumstances of the applicant, that cannot be unnecessary hardship. Example of that, one of the hardest cases I ever had back in the dark ages when I was working with CAMA, I had a case down south. A couple had bought an oceanfront lot. Couple of modest income working out in Gastonia had bought a lot on the oceanfront, but they couldn't afford to build anything on it. They saved up. 20 years after they bought the lot, they were ready to build a small cottage on their lot. Tiny lot, so they didn't have much space. They came in and asked for a variance from the elevation requirement for the structure. They had to be up something like 13 feet above grade for flood hazard elevation. They said, we can only be, the problem is the wife is now elderly, has severe arthritis, and is confined to a wheelchair, and we've explored the ramp angles, and in order to get a ramp that we can effectively use within the property bounds, meeting the oceanfront setback and the street setbacks, we need to drop the elevation about 2 feet in order to build this ramp so this lady can get into the cottage. My job was to be the staff person to argue to the commission that that was personal circumstances and was not unnecessary hardship. And the little old lady in the wheelchair was there, sitting in the front row. And I felt terrible. But it didn't meet the standards. It was her personal circumstances. They could meet the elevation requirements and have steps that went up it perfectly fine. But because of her personal health circumstances, they wanted a variance. And you can logically say, it won't be safe for you to be there because you're not above the flood level. It's going to harm the neighbors because your house is going to be too low and it's going to get damaged in the storm and the debris is going to smash into the houses across the street. But you're looking at somebody saved up 20 years, sitting in a wheelchair in front of you saying, I just want a beach cottage I can enjoy for a few years before I pass on. I felt awful, but personal circumstances, and she didn't get a variance. I mean, the commission voted against the variance. Every one of the commission members, I think, gave a 2-minute speech about how bad they felt about voting against her and how they hoped she could find another lot that would work, but it just didn't meet the legal standards. I mean, everybody felt terrible about it, but it's personal circumstances. Somebody's financial conditions. I'd like to comply with this, but it's going to cost more money, and you know how the economy is. I've been out of work. You can feel a lot of personal sympathy for their situation, but personal circumstances cannot be the basis of unnecessary hardship. It has to be something about the property. I would like to comply with the ordinance and build according to the standards, but the other thing is not common to if it's something that every lot in the neighborhood or the general public has, then the proper remedy is to amend the ordinance to address the problem, not to give that individual a variance. I had an example of that. I dealt with a small town that had a lot of lots created in the 1920s. And now they wanted to build detached garages, and cars are a lot bigger than they were in the early 20s, and they didn't have enough space to put a detached garage in this whole neighborhood and meet their side yard setbacks. And so one person asked for a variance. Well, the question is, well, you can't give that. That's a common situation in this whole old neighborhood. You need to amend the ordinance to change the setbacks or not in that context. One of the things that's new is the statute says you do not have to show, however, that you could make no reasonable use of the property without a variance. That's a standard that some local governments had put into their ordinances. A few states have required. It's never been the law in North Carolina, but some ordinances have it. You're not required to show that. Otherwise, anybody want to guess the percentage of variances in North Carolina that are granted? The staff always kicks me under the table when I tell you the answer to this, but 82%. And that's fairly consistent around the country and over time, from the 1940s to more recent times. Around 75, 80% get granted. Do 75 or 80% meet this standard? I know they do not meet this standard. Where they meet the unnecessary hardship, maybe. But if this was a standard, it hasn't been observed, is I guess my point there. Another thing that is now in the statute, the hardship must not be self-created. If I put my foundation in the wrong place, and it's sitting in the setback when the folks come out to do the foundation inspection, and I come in and say, I would like a variance because it's going to cost me a whole lot to dig up this foundation and move it. Tough. That it may be hardship, it may be expensive, but it is not the basis for a variance.
Who said it was okay?
Who said it was okay?
Building inspector.
Oh. Well, we had one, not in Dare County, but somebody built a huge detached deck adjacent to a canal in an estuarine shoreline without any camera permits, and they'd already built, they'd spent something like $6,000 on a very elaborate deck inside the setback without getting any permits. And their argument was, but it's a perfectly good deck, and I can't salvage much of this material. It's going to cost me $6,000. It's going to be lost. That's ridiculous. And the court said, you messed it up. You're the one who built your deck without a permit in the first place. It's in the wrong place. It's got to go. Yes, it's a hardship, but it is not it's a necessary hardship and a self-created hardship. Now, if you got a permit for it, that raises a whole nother can of worms. Technically, you get no legal rights based on a mistakenly issued permit. So if the permit was a mistake and the permit is revoked, the officer who issued the permit may be updating their resume, but the applicant gets no legal rights based on that. Anything about variances and what kind of hardship, because that is, I mean, it really is a hard thing, and it is a judgment call. One of the other things to remember is hardship is only one part of the equation. That's a threshold inquiry. If they don't have unnecessary hardship, variance is out of the question. But even if they do show you unnecessary hardship, what they're asking for still has to be consistent with the purpose and intent of the ordinance. So one of the things you have to think about is, why is this requirement there? And would granting this allowance, this variation in the standard, still allow the purpose of the ordinance to be accomplished? Another standard you have to think about is that, you know, the sort of substantial justice done means, what impact is this going to have on the neighbors? So if what you're allowing would create a harm to the neighbors or to the public interest, you should also deny the variance, even though there's a hardship. The whole notion is, when the ordinance was adopted, you couldn't think of every individual circumstance, and there's some things where a little bit of wiggle room is appropriate, where the ordinance is creating a hardship. You can grant that relief and still meet the purpose and intent of the ordinance and not harm the neighbors or the public, and in that case you ought to grant that relief. But without that, you shouldn't. Without that, you need to tell the folks they're barking up the wrong tree. With a variance, they need to go talk to the city council about changing the ordinance. But you've got to have unnecessary hardship, still meet the intent and purpose of the ordinance, and not harm the neighbors or the public interest. And all of that is a very difficult balancing act for you to make. But that's why boards of adjustment get paid such big bucks, right? Is to make those tough, hard decisions. And it is difficult. but that's where you earn your keep, is making those decisions. Any questions, thoughts about that? You say, wait a minute, where's my check? Where's these big bucks you're talking about? Well, that's pretty much all I've got. We're at our 11:30 hour. I just want to thank you. And one of the things I really do want to conclude with is thanking you for your service. Most of the folks who are on boards of adjustment, Dare County may be different than most places. You may do a difficult 2-hour hearing and decision, and people who are in the audience on the losing side of the case may come up to you after the hearing and say, boy, this was a long, hard slog. I disagree with the decision you make, but I really respect your hard work in public service and appreciate all you do for our community. Thank you from the bottom of my heart.
Happens out there by you?
I have never seen it happen anywhere, I don't think.
Anybody in this room seen any?
Yeah. But it really is important work. I mean, this is a lot of the place where the rubber meets the road and where fairness and justice is dispensed in a way that not only affects the individuals who are appearing before you, but if you do your job right and do it well, it really does benefit the community over the long term. And if you didn't do it, it would be noticeable when you come back 20 years after the fact and say, whoa, who was asleep at the wheel when these bad things happened? And particularly in this part of the state, you're dealing with resources that are incredibly valuable, incredibly important, and the character and quality of the community depends on the largely thankless task that you put in month after month. So as somebody who comes and enjoys the area, I certainly appreciate it, and it's a great public service for your communities. I know your staff is around and delighted to help you do a good job of that. If we can be of any help at the School of Government, we're glad to do that. But it's your service day in, day out, month in and month out that makes these communities a great place to live and work. So thanks very much and good luck.
Thank you.
David, I want to thank you